All new public officials, including assessors, should be aware of several laws that regulate how they conduct public business. The purpose of this lesson is to familiarize you with the basic principles of four of those laws: the Conflict of Interest Law, Uniform Procurement Act, Public Records Law, and Open Meeting Law, and to direct you to the state agencies that interpret and enforce these laws. Contact and website information for these agencies is found in the introduction of the Course 101 handbook. Staff in these agencies are available to answer your questions, and you will find advisories, publications, and other helpful guidance on the websites. The Conflict of Interest Law establishes minimum standards of ethical conduct for all state, county, and municipal officials and employees. Its purpose is to promote public confidence in government and the integrity of its officials and employees. The State Ethics Commission has the general responsibility for the interpretation and civil enforcement of this law. Civil enforcement includes imposition of fines and voiding tainted actions. There are also some criminal penalties, including fines and imprisonment. Bribery, for example, is a felony. Criminal prosecutions are the responsibility of the Attorney General and district attorneys. The Conflict of Interest Law applies broadly to all state, county, and municipal employees. You are an employee for this law if you hold any office, position, employment, or membership in any agency, department, board, or commission of your city or town. It does not matter whether you are elected or appointed, full or part-time, paid or unpaid. However, some provisions of the law apply less restrictively to those holding unpaid or part-time positions that have been designated special municipal employees by the Select Board or City Council. For example, in some towns with elected boards of assessors, the position of assessor is designated a special municipal employee. In general, the law restricts activities that occur on the job, after hours, after government service, and governs general conduct. On the job, you cannot ask for or receive anything of value in return for performing your job. You cannot generally accept any gifts from people you have official dealings with, even if well-intentioned. For example, sporting event tickets or dinners. You cannot engage in nepotism, that is, appoint, promote, or supervise your relatives or recommend pay raises for them. You cannot take any actions that involve or affect the financial interests of you, your immediate family, your after-hours employer, any business or nonprofit organization in which you are an officer, director, partner, or trustee. Your immediate family includes your spouse, parents, siblings, and children of you and your spouse. Property owners are presumed to have a financial interest in matters affecting abutting and nearby property, as well as their own. This means, for example, that you cannot participate in valuing or granting abatements for property that is owned by or that abuts or is nearby property that is owned by you, a close family member, or business in which you have a financial stake. After-hour restrictions limit your receiving municipal contracts or holding multiple jobs. The purpose of these restrictions is to ensure public employees don't use their positions to benefit from contracts and to avoid the perception that current employees have an inside track on contracts and jobs. For example, you cannot generally hold more than one paid position with the community or enter into contracts with it. There are numerous exceptions to this. You can hold more than one elected position, and people holding positions with a designated special employee status may hold multiple paid positions if certain technical requirements are met. You cannot use your position to obtain special privileges or give the impression you can be influenced or will be biased. You cannot disclose confidential information you gained or learned as a public employee. After government employment restrictions limit lobbying and other activities involving your job and agency. Some of these restrictions apply for a limited period of time, and some are forever restrictions. These limitations are intended to prevent misuse of government connections, the so-called revolving door. There is also a general standards of conduct provision that prohibits any action that give the appearance of impropriety. You are responsible for determining whether a proposed action presents a conflict and acting to avoid that conflict. The State Ethics Commission has various publications, advisories available that explain the conflict of interest law generally, and its staff is available by phone and email to answer general questions. Municipal officials and employees who wish a formal written opinion about whether an activity they propose to engage in would violate the conflict of interest law should contact their town council or city solicitor. The Commission provides an online training course which you must take within 30 days of employment and every 2 years thereafter. It also provides a summary of your obligations under the law, which your city or town clerk will provide you with within 30 days of your employment and every year thereafter. You must acknowledge receipt. Both the training and summary acknowledgement are required by the conflict of interest law. The basic law governing procurement is the Uniform Procurement Act, also known as Chapter 30B. Chapter 30B establishes uniform procedures for public officials to follow when buying or contracting for supplies, equipment, services, and real property. It applies to cities, towns, counties, special purpose districts, regional school districts, and local authorities, such as housing and redevelopment authorities. Chapter 30B is based on 3 premises. Larger contracts should receive more attention than smaller contracts. For example, there are streamlined procedures for small purchases so local officials can devote their time to larger contracts, basically over $50,000. Fair, strong competition for larger contracts saves tax dollars and promotes integrity and public confidence in government. And the use of uniform bidding in contracting procedures promotes competition and fairness as it clarifies bidding procedures for vendors competing for contracts and for citizens observing the process. Chapter 30B applies to almost all purchases and contracts to buy, rent, lease, or otherwise acquire supplies, equipment, services, and real property. It also applies to the disposition of surplus supplies, equipment, and real property. Most of the supplies, equipment, or services purchased for use in your office would be covered, for example, computer equipment. In addition, contracts for professional and data processing services, assessors customarily use, are covered, for example, revaluation contracts, specialized appraisal services, such as an appraisal of a power plant, and printing services. The Chief Procurement Officer for your city or town oversees these procurements. The Office of the Inspector General has the general responsibility for the interpretation and enforcement of Chapter 30B. It has various publications, brochures, and advisories available that explain the law generally and with respect to specific situations. For example, it publishes a detailed Chapter 30B procurement manual and a procurement bulletin, which is a quarterly e-newsletter that discusses issues that arise under the law. The Public Records Law provides access to records that document the conduct of public business. It is found in 2 statutes. The law defining what constitutes a public record in Massachusetts is found in Massachusetts General Laws, Chapter 4, Section 7, Clause 26. If a record is public, another statute, General Laws, Chapter 66, Section 10, provides a right of access, either to inspect it or to be provided with a copy, to any person regardless of motive or intended use of the record. The Supervisor of Public Records within the Office of the Secretary of State is responsible for interpreting and enforcing the Public Records Law. It has various publications and provides other guidance on the law. Public records are defined very broadly to include all documentary materials or data, regardless of physical form or characteristics, made or received by state, county, and municipal offices. This includes paper records and records generated, retrieved, or maintained electronically. Each form is a separate independent record. Most of the records generated by your office in the regular course of business are public records, regardless of their form. This includes, for example, your property record files, valuation books, list of granted abatements, and exemptions, and minutes of board meetings. In addition, records that originated in another office, for example, copies of deeds you received from the Registry of Deeds, are also public records of the Assessor's office. If you have them, they are public records of your office. The law also establishes a limited number of exemptions from the mandatory disclosure provisions of the law for some kinds of records. Note that to withhold disclosure of a record, a statute must specifically exempt the record from disclosure. You cannot deny requests for records because of concerns about privacy or how the information might be used. Some of the assessor's records are confidential and exempt from disclosure by state law. A listing of those records is found in the introduction of the Course 101 handbook. Generally, they are documents submitted by taxpayers that may contain private information about personal or financial matters or property holdings. They include abatement and exemption applications, personal property schedules in forms of list, pre-assessment and abatement information requests, such as income and expense statements from commercial and industrial property owners, and appraisal reports prepared for appellate tax board appeals. Your city or town must designate at least one records access officer called an RAO to respond to requests for public records. Requested records must be provided without unreasonable delay, but in no event longer than 10 business days. If produced within this period, the RAO may charge a fee to recover the cost of fulfilling the request. However, the amounts that may be charged are limited by the law and regulations issued by the supervisor of public records. A requester who is denied access to a requested record may petition the supervisor of public records for a review and determination. The supervisor may order disclosure, and the supervisor's decision may be appealed to Superior Court. Alternatively, the requester may bring an action in Superior Court to compel disclosure or seek compliance with the law. You must work with your RAO and municipal council to ensure that your office understands and follows your local procedure for complying with the law. Failure to comply with the deadlines and procedures in the law could result in your city or town having to pay the attorney fees and litigation costs should a requester be successful in court. The court can assess damages of up to $5,000 for certain violations. The open meeting law is interpreted and enforced by the Office of the Attorney General. The law promotes a basic premise of our democratic form of government. That is, the public should have access to the decision-making processes of government. This encourages public awareness of how government works, not just its results, and promotes accountability on the part of public officials. The law has 4 basic requirements. First, all meetings of government bodies must be open to the public. Governmental bodies, including every board, commission, committee, or subcommittee of a city or town. In other words, it applies to multi-member bodies such as your Board of Assessors, but not individual officers such as a mayor or town accountant. Meetings of the Board of Assessors are covered by the law. A meeting is deliberation of a government body for which a quorum is required in order to make a decision, or attempt to make a decision, on a public business or policy matter within its power. Deliberation means any oral or written communication, including email and texting, among members of the body on such a matter. On-site inspections and attendance at training programs and conferences by a quorum are not covered meetings, so long as there is no deliberation. Second, except in emergencies, notice of every meeting must be filed by the officer in charge of calling the meeting with the municipal clerk in sufficient time that it is publicly posted for at least 48 hours before the meeting is to take place. The 48 hours excludes Saturday, Sunday, and legal holidays. The notice must include all subjects the chair reasonably expects to come up at the meeting. Third, a governmental body may meet privately in what is called executive session, but only when certain procedures have been followed, and only for specific purposes stated in the law. For example, since abatement and exemption applications are confidential records under state law, you may go into executive session to discuss information contained in those records. And fourth, Governmental bodies must maintain accurate records of their meetings and votes. Persons believing that a governmental body violated the law may file a complaint with the governmental body and, if dissatisfied with the response, with the Attorney General. If the Attorney General finds a violation, the Attorney General can invalidate the action taken, order training, impose a penalty of up to $1,000, or compel other remedial action. In addition, the Attorney General or three or more voters can also bring an action in court to enforce the law. The Division of Open Government is the unit that carries out the Attorney General's responsibilities under the Open Meeting Law. Like the Conflict of Interest Law, the Open Meeting Law requires that new office holders or employees review materials available from the Attorney General about the law and certify receipt to the city or town clerk. These materials include the law itself, regulations issued by the Attorney General, and a guide issued by the Attorney General. The division also publishes frequently asked questions, checklists, and other materials of assistance to local officials. Its staff is also available by phone and email to answer general questions, and it provides training programs for local officials on their obligations under the law. You should work with your municipal council to ensure that your procedures for conducting meetings, going into executive session, and handling complaints against your board comply with the law. Let's review the key laws that govern your conduct as a public official and the local and state officials who are your key resources about those laws. First, the Conflict of Interest Law sets ethical standards. Questions should be referred to your municipal council or the State Ethics Commission. Second, the Uniform Procurement Act, or Chapter 30B, establishes procedures for acquiring supplies, services, and equipment for your office. Your Chief Procurement Officer, Municipal Council, and the Inspector General's Office can provide guidance. Third, the Public Records Law requires mandatory disclosure of records within 10 business days of a request. Your Records Access Officer, Municipal Council, and the Supervisor of Public Records in the Secretary of State's Office are your key resources for determining whether a record is subject to disclosure and ensuring that all procedures are followed. And fourth, the Open Meeting Law applies to meetings of a quorum of your Board of Assessors on matters within the board's purview. To ensure you have complied with the law, you should consult with Municipal Council and the Division of Open Government in the Attorney General's office.